Okay. What would be helpful uh, is uh, to come. It appears that the effort to make a compromise using the juvenile system doesn't work as well as I had hoped it would. Um, but but that was based upon when I came up with the idea of the Department of Public Safety or the commissioner saying it worked. But I understand the concern is access to their records. Is that what is going on? It's one of the things. But this thing is more and more complex as we try to move along. And I appreciate, and Jennifer, I'm sorry, I did cut into your discussion and then we went on to Evan um, and Marshall. And I guess what I'm trying to understand from everybody before we go live, just to make sure everybody's clear.
We are live.
I'm trying to, oh, okay, great. I'm glad we're live. I'm trying to understand where everybody's concerns are, either with the House bill passed version or with the idea of changing it to the juvenile system, and what are the problems that we're seeing, and so that we can come up with something. But I heard that there were, so going back to the original discussions about problems with the House passed version, as Senator Baruth noted, we have a system already of expungement. This was supposed to be a one-track system, but if that isn't going to work, we don't, we can add a few crimes to the expungement list and move on. So Tucker, fire away. And I apologize to everybody who I might have cut off or not cut off.
Good morning, Mr. Chair. Good morning, Senators. My name is Tucker Jones. I'm Assistant General Counsel for the Vermont Department of Public Safety. The specific concern that precipitated a lot of the department's concerns with this bill was the deletion of the provision that criminal justice agencies can use sealed criminal history records for criminal justice purposes. And so that was deleted in the House version, and that's currently an existing law. And the Department of Public Safety relies on that provision for two of its systems, as Commissioner Shirley, I believe, has previously testified in this committee. One is the law enforcement's computer-aided dispatch system, and the other is the Crime Information Center's criminal history records. It's really a record of arrest and prosecutions, known as a rap sheet. And historically, the departments relied on that provision to use those records internally and among government entities for access. And so we put together a memo. It's a 3-page memo on the legislature's website, but it's under the House Judiciary for this bill. And I can provide it. So it's on the Senate Judiciary's website as well. But it lays out what we viewed as the practical implications of deleting that provision on those two specific systems. And so as a threshold issue, we'd like to at least leave that provision alone, leave it in existing law. So at least for now, those systems can continue to operate as they currently do. However, I think the broader conversation, as we've delved into the details of this and the effect of sealing on all government entities, is related in part, and the frustration is related in part to the fact that our existing scheme doesn't provide much direction on what government entities are supposed to do with sealed records. it provides very clear guidance on what the judiciary does with its own records. And so what has happened, I think, over the this is my assessment, is that the judiciary sends out sealing orders to the relevant government entities that may possess records subject to sealing. And the government entities have relied on complying with those sealing orders to effectuate their obligations. And whatever those sealing orders say, government entities comply with. And I believe they're standardized orders at this point on this is what happens when a record's sealed, and it's essentially an order directed to various government entities. The question becomes now there's every government entity does different things with sealed records, and there's a lot of questions on what the expectations of the legislature are with what we should be doing with these records, especially from the law enforcement perspective, in light of the deletion of this provision that we could previously use the records for criminal justice purposes. And really the question becomes, well, what does it mean that that's now deleted? And how do our operations have to change with the management of those systems so that we can comply with whatever the law is? That topic has not been fleshed out in great detail about the effect on all the government entities. And we haven't yet looked to how New York does it or how Pennsylvania does it in regards to government entity access to sealed records. And so we've been trying to sort out what the best approach would be. We do have significant concerns, unfortunately, with the juvenile 5119 provisions, applying that to at least DPS records, but I think there are also questions for the other government entities as well. In the meantime, since we initially viewed the 5119 provision and realized that it would be problematic, we were trying to craft something else along the lines of, after a certain period of time, government entity access would be closed. And so I have already talked with Jeff Whalen about that, and to try to figure out how it would impact his operations. And we haven't, it was clear from the emails that would create its own set of questions and operational and policy on his level on how it's going to be implemented if you have a 7-year window after sealing of what we're actually going to do with that record after 7 years. So I worry about creating something like that on the fly. And from the department's perspective, there may be value in taking an enterprise approach for all government entities, the way that some other states do, to address it in its own statutory provision, to work out the technical details. Because obviously there are policy implications in all of this, but there's a lot of technical implications that are really related to how we manage existing computer systems. And we have to meld those two. And that's a big project. And I'm willing to help with that project to sort out, because we have with Jeff Whalen in the Crime Information Center, that's a key piece of criminal history record information, and to try to meld that into a scheme that other states have already created that is responsive to the needs for government entities to have some level of continued access to their own records, while of course shielding those records from public view. And so unfortunately, that's where we stand today, where that project is probably worthwhile, but it's just really coming up now, and the breadth of the issue and the impact on all the other government entities is really coming into full view. So maybe I'll just leave it there. I know that that's not an answer that we can implement today. I worry that if we did create that enterprise level scheme to address government entity access, it's probably not worth rushing it, so we can actually make sure that it works for all the entities and their technical systems today.
Mr. Chair?
Yep.
Tucker, just a couple questions. So am I understanding you right that it feels to me like you're arguing that we go back to the study committee stage?
I know I'm not arguing for that. I know it's, this has already been in front of Joint Justice, and the focus up to this point has really been, I think, at least in the House, which offenses, how long people have to wait. And we hadn't really hashed out all the implications for government access. At least it really only arose for DPS with the deletion of this provision for criminal justice agencies for criminal justice purposes. And in this memo to the House, we laid out, we thought there were some unintended consequences of that when I spoke in detail about, with Jeff Whalen, about how the Crime Information Center operates. And it is ultimately technical, but I think it requires that level of, technical work to make it work for everyone.
Okay, my other quick question is, when you, in a glancing way, you kind of mentioned the idea of an additional window of time in which the records would be accessible for law enforcement purposes. So I'm wondering, in our journey on expungement, one of the things we've done is to try to establish a timeline after which we feel that the information is no longer relevant, given the nature of the crime. So that's part of the qualifying list, was after 10 years or so, what would be the import of this information? Would it be worth anything to anyone after 10 years? And so we settled on that, and that became the window for expungement. Now it seems to me, if you're talking about an additional 7 years, so if I understand right, what you're talking about is 10 years where the public has access and everybody has access, then 7 years where only law enforcement has access, or the courts, and then full sealing. I wonder why we would go to the process of having a second window. Why not just adjust? If you don't believe that 10 years is the correct metric for when expungement or this new form of sealing should occur, why not just adjust that rather than have a double window, in other words?
I hear exactly what you're saying, Senator Baruth, and I think what I was getting at is the problematic operational effect of having a double window, because it essentially creates, it creates double the work for whoever's doing it, whoever's keeping track of the time frame, et cetera. But there are two policy interests at stake here. One is to help individuals, escape the collateral consequences of a conviction within relatively short period of time. And there was kind of quite a bit of discussion on the 3 years for misdemeanors, 7 years for felonies, et cetera. And then it's really a separate policy implication of, well, what about government entity access, separate from public view, in a way that doesn't impact employment or housing in most circumstances. And it's just a whole nother set of policy implications that we're in a way scratching the surface with today on, what is the effect on the child protection registry? Questions came up in communicating with Jeff of, should any sealed records be disclosed to a background check for certain entities like foster placement? Should they have access to the fact that someone has a dismissed and sealed lewd and lascivious charge? I'm not saying that should be the case, but those types of questions start to arise as soon as you scratch the surface on these issues.
Right, but our bill doesn't include lewd and lascivious. So I guess,
Dismissed, it does, right?
what's that?
If it's dismissed, it would.
Right, but that wasn't created by our bill, right?
That's current law.
That's current law.
Yeah.
So I guess what it boils down to for me is, and I think no matter how often we address this, we'll come back to the same point. So I've said this before, I'll just say it again. We live in an information age, and there's a reason why all of us get deluged with requests for, will you fill out a survey for our company? Will you fill out a survey for this agency? Because everybody is crazed for the need for information and to protect their access to information, because in our society, that's where true power for an individual or an agency lies. So, this is a bill that would cut off information to various agencies. And not surprisingly, we're hearing complaints throughout the process about that. And I just think it's to be expected that, DPS, DCF, other branches of government will never agree to willingly give up their access. But again, we're moving from expungement to something closer to sealing, but that has the characteristics, some of them, of expungement. And if we're going to accomplish that, the one-track system, both sides have to give up something. And I feel like what's happened is the expungement side has given up, and we've moved into a situation in this bill where all of these agencies have access with a court order. And for me, that was a give. But I feel as though no matter how much we are to give, the other side, that is the side that prefers sealing with access for justice purposes, will never really support it, because again, it's a basic principle of not wanting to give up access to information once it exists in the system. But that's what expungement is about, is everybody in society giving up access to that information to help the person get on with their life. So I'll just say that that's my general comment. I'll be quiet now.
Senator Sears, can I ask a question?
Sure.
Tucker, in the effort of not throwing the baby out with the bathwater, are there any of the listed offenses that you take issue with if we are to actually pass something that tweaks the listed offenses that are dealt with here?
Well, are you using the term listed offenses, in its technical sense?
I shouldn't have said it that way. I'm talking about the bill. The bill has certain misdemeanors and felonies that are tweaked in some fashion. Do you have any problem with any of those?
There are, in this bill, there's an addition of quite a few felonies. And one of the implications of that is, my understanding is some of those may be Brady disqualifying. And in my conversations with the Criminal Information Center. And right now, those convictions would be remaining on someone's criminal history record. And they would remain there even after they're sealed for firearm eligibility purposes, under the provision that allows criminal justice agencies to use it for criminal justice purposes. And so what happens, like one of the issues, and we put this in our memo, is if in fact those are Brady disqualifying felonies, and we no longer can use the sealed record for criminal justice purposes, the effect may be that it restores someone's eligibility to possess a firearm upon the sealing, because we would then effectively remove it from someone's record of arrests and prosecutions. And so I apologize, that wasn't fully responsive to your question, but it's the type of issue that arises when we start adding offenses to it. to the list. I'm not saying that, those offenses shouldn't be on there. The focus really has been for the Department of Public Safety to ensure that continued government entity access is permitted. The commissioner fully understands and appreciates and supports the idea that people should be able to move on publicly from the collateral consequences of a conviction, in terms of employment and housing, etc. And so I'm reading it more on like the technical implications of those offenses. And that also, that's in the Crime Information Center. There's other implications for the computer-aided dispatch system. And we lay out the explanation for what the department views as, legitimate or bona fide purposes for continued access to the underlying incident information from those types of offenses, including some of the felonies that are on this list, which are quite serious, but also any offense that happens to be dismissed and is sealable potentially within 60 days. And maybe I'll just leave it there for now and refer to that memo as providing kind of more details on the rationale that law enforcement has for why they think continued access once a sealing order is received would be appropriate. I understand it's a point of contention and policy debate.
Senator Sears, may I ask
Yeah,
Tucker a
please.
question?
Yeah, sure.
So Tucker, I understand some of the concerns, and you mentioned Brady, an offense that might be Brady, I don't know the term, Brady eligible, whatever. And I just went through the felonies that were added here, and I can't see anything that would qualify as, I just went through them, and maybe I'm naive and don't know what they are, but there is nothing in here that I think would qualify, would prevent them from owning a firearm. And
in my conversations with the Crime Information Center, one of the disqualifying offenses is any crime punishable by imprisonment for a term exceeding 1 year, which, if that's the case, and forgive me, I'm not an expert in this area of the law, but if that is the case, then it would be all of these felonies.
But I think that I might be wrong here, but it seems to me that when we passed the corresponding law to report to NICS, that we specified our list is not the same as the federal list. Our list is is smaller list, and it only involves crimes where there were arms involved, but it's a smaller list. So our list is different than the federal list. So why would we care what the federal list is?
And Senator White, I'll defer to you on that, because honestly, I'm not familiar with the relationship between the NICS system, and I'm just not an expert on the implications of that. So I'm not, but this was a concern raised by Jeff. So we did include it in our memo, because there was some concern that potentially, perhaps in other states, they would no longer realize that someone was disqualified here if it ends up being sealed, if they use the federal standard.
I think, am I right about that, Joe, that when we did it, we looked at the list, and the offenses that we report to NICS are fewer than the offenses that are federally. Am I right about that? We spent a lot of time on that.
That discussion.
Yeah, because there were certain offenses that
There was another, not to confuse everything, but there was another bill where we put down crimes that Vermont would be able to, with firearm possession. I can't remember exactly the details of the bill, but we didn't do all of the crimes that are So if a felon is in possession of a firearm, we didn't do all the crimes. We made certain crimes eligible for enhanced penalty. The federal law, because so few federal prosecutors would take on those cases. I think that may be the bill you're referencing.
Yeah, I remember looking at the list and, yeah.
And I apologize that I don't have all the answers for it. It was just one, it was a concern. We didn't have, it hadn't been ironed out. And I guess that is the broader, point I'm making is that it had become clear to me by the time that this had passed out of the House that the provision in 7607C2 for criminal justice agency access was in a way the tip of the iceberg in terms of the implications for all the other government entities that receive sealing orders. And we just hadn't worked through what the implications on all the government entities were. And it seems that other states have worked that through. So it just may be valuable to do the same thing, even informally, to provide to the legislature, some options on how other states do it and how that would be incorporated into our government entities here, to address the concerns about what all these government entities are supposed to do once they receive a sealing order, because there's this great hesitation on doing anything untoward with the underlying documents if we have an order that's saying you shall do X, Y, and Z with this sealed record. And so in a way, those sealing orders that all the government entities are receiving, they've become the guidance in a way on what to do, absent clear statutory guidance on how government entities are supposed to handle their own records.
Okay. So all that crossed out language on 7602 is where the procedure, that's what you're talking about.
I'm not sure what you're referring to, Senator Sears.
You said 7602, is expungement. They crossed out expungement, sealing of record, post-conviction procedure. That's section 2 of H 530. And they crossed out all of the conditions with the current law regarding the sealing.
Page 7.
Page 7. Yeah, it's at the beginning.
Is that what you were referring to?
No, I'm sorry. The specific criminal justice agency access to sealed criminal justice, criminal history records for criminal justice purposes, that's in 7607. And this is in terms of government entity access.
Okay, the effective, okay, thank you. I thought you said 7602. All right, the effective sealing. And then it says that the government entities may only access sealed records only in the following circumstances. So if we took that out, be okay with the bill.
What's on page 21, is that what it?
Yeah, I think.
21 of I'm looking at the original bill, and we.
Yeah, I am too. It was passed by the House.
Yeah, we took that out, the DOC and state's attorneys and criminal justice. We took those out.
took it
Right.
out, meaning
We
we
took it, it
put
was
it back in when the house took it out?
no, the house had in there that they had access to, that DOC had access, and that the state's attorneys had access, and the Victims' Compensation Program had access, and criminal justice system had access. They had that
Go
in
back-
here, and we
go
took
back
it
to-
out.
Go back to page 19 of the
No.
bill passed by the House.
So the house changed it so that they didn't have access.
Right.
Or is that?
This is as passed by the House, and it says that those people have access for those purposes.
Help us.
Yeah, so if I could just focus just on DPS and on the law enforcement piece, they currently have pretty much unfettered access
Yeah.
to sealed records for an unlimited time period for criminal justice purposes. The House eliminated that access. There are certain circumstances under the House proposal for certain entities to do a look back at sealed records for a certain amount of time for purposes of risk assessments and supervision and for sentencing. So those are the kind of main circumstances. Then your new draft eliminated that and went to the sealing thing. I think what I understand, and Tucker, correct me if I'm wrong, is DPS is sticking by their consistent testimony through all of this, is that they want to retain the broad discretion for law enforcement to continue to have access to criminal history records for their purposes. And then the other issue that he's brought up is not so much anything that's addressed in this bill, but is an issue of just the fact that under the existing system that you have sealing orders, you have all different types of options for records to be sealed, but that there is not a one consistent policy that directs each agency about how they're to seal those records and what they do about that. And so that is true. There may be, like in certain ones, they may say, like in the Title 33, there's a special index and things like that. I would say that that's obviously a related issue, but it's not the issue that's before you in terms of the access issue. So, you may decide that there's a good point there, and that perhaps, because Sarneka, you brought up the issue earlier about, well, how do you know that somebody's not accessing records without authorization, and who polices that, or how are their checks and stuff? And I think that's an issue, but that's more of just like a general records management issue as to sealed records, and is there consistency among the entities so that we know that the court has a real structure that Lori can talk about of how they do that. But everybody else out there may be doing it in their own separate ways. But can I also just address just really quickly, the issue of, whether it's doing a firearms background check or something like that. We obviously can't control what the feds are doing in terms of how they're going to treat a sealed record, and it isn't entirely clear to us at the federal level there. If you want to, we could always craft language that's targeted specifically at that, depending on what your policy decision is. So the House chose not to create any kind of new specific exemption in there, and I can't speak for the committee as a whole, but I know that members had raised the issue of, like, well, if we're sealing rights back and the restoration, shouldn't being able to own a firearm be part of that, especially when we're looking at the types of offenses that are on the list that are eligible for sealing. But somebody else may have a view, no, even though it's sealed and you're essentially being made whole again, you may decide from a policy perspective, you still want it to be a bar to that. But there's a certain amount of that, we're only going to be able to control our end and not what the feds do. But I'm just saying is that depending on what your policy is, if there are concerns about wanting law enforcement to have access for certain particular reasons, we can target that rather than what you have under current law.
And if I could, Senator Sears,
Where is?
Senator Sears?
What chapter is this in?
Oh, I can't hear you. Is it all right if I go ahead?
Yeah, go ahead. You can't hear me? I don't know what's
Okay.
wrong.
Well, now we can. So I feel as though we're on the cusp time-wise. If we only have 2 weeks left, I don't feel that we can go down some of these roads that seem to me maybe necessary, but fully possible to do next year or the year after. So a bill that would specify, more clearly processes under sealing for various agencies, or collateral effects like the NICS database for firearms. I feel like those would take more testimony and more time. So I feel as though we should focus in on what our approach is generally. I still support the approach that's in this draft in front of us. I understand, I think, why the agencies that are described there don't like it. But it seems to me until we pick a basic approach, the clock is going to keep running out, and we're going to wind up with no bill regardless of what we want to do.
Okay. Can you hear me now? Are you hearing me?
Yeah.
Yes.
Okay, so if we were to focus on the House passed version rather than the draft that we had this morning that Michelle worked so hard on, and we were to take out the struck language on page 20 and page 21 regarding the access to, and if this was agreeable to the committee, obviously it would need to be, what would be the impact of that?
Is that a question for me, Senator Sears?
Question for anybody. Yeah.
Well, I think if you left 7607 alone, largely alone, then it would be the preservation of the status quo for now, as far as DPS is concerned.
And so going along with Senator Baruth's proposal, what if we sunsetted that section and would force to come back in 4 years or 3 years or whatever?
If you left 7607 alone as it currently exists in law,
Right.
then that would preserve the status quo. And then without importing this 5119 provision or anything like that, and then we would just be where, in terms of government entity access, as far as I know, we would be in the same boat that we are right now, and all the things I was talking about could be presumably ironed out off session. With proposals to you where we do all the technical legwork of the implications on the various government entities. And then if you wanted next session, if you wanted a more coherent scheme on government entity access in 7607, more than whatever C2 provides, then we could pick it up then.
Yep.
If you're looking for input, I couldn't support that. But there may be a majority on the committee who would.
I'd have to see it. I mean, I'm so confused now that.
Well, it would continue to give law enforcement access without limitation for criminal justice purposes. And one of the problems for me is roadside stops, where we've been consistently given data showing that it's plagued by racial bias as well as other things. And if without limitation, to me, that says that any law enforcement officer could access it within the scope of their daily duties. And, that's not just moving away from expungement, that's completely getting rid of expungement and just sticking with, it's eliminating the expungement that we had put into law and going back to a system where the person would have no privacy for those records, whether the public could find them or not, because law enforcement could still access them at any time.
It's frustrating to me is that this entire conversation began when a woman came to us and said, my particular crime is not fitting into this very well. And we tried to move to make that change, and it's still pending here, and I hate to throw that baby out with the bathwater.
Yeah.
Well, I think the bath is getting a little cool right now.
The bubbles have all disappeared.
Bubbles are disappearing. I think it's a problematic. I mean, I'm willing to look at a certain period of time where the access is there. So if you go to misdemeanors, what's the current misdemeanor limit for time, Michelle, on the current law?
I'd have to,
It's 3 years.
yeah, I think it's 3 years. I'd have to look. You don't mean under the
Under the-
proposal? For
What?
when you're
No.
eligible to seal?
Under current law, if you have a misdemeanor, when are you eligible to seal?
I don't think it doesn't necessarily fit into the same categories, but I can take a look and let you know.
All right,
I mean, I
So-
think, can I just make one point? I just want to make sure is clear, is that if you leave the structure of what you have in 534 and moving to a one-track system, and then, but you also leave the access, or what sealing means, and the access to sealed records, you will actually be increasing the number of records that law enforcement will be able to view, because as Senator Baruth said, you're eliminating expungement as a path. And so you're taking those, what would be expunged, putting them into the sealing category, and under sealing, under current law enforcement has unrestricted access. So you can certainly do that. I just wanted to tie that in, is that if you take
All right.
if you take part of it and then eliminate another section, that is what you wind up with.
yep. So, yeah, it's just a conundrum. We want to get a bill that the governor will sign. On the same token, we want to have people have the opportunity to remove the collateral consequences of their behavior if they've been free of any new charges and any new criminal activity. I feel like Paul Newman in Cool Hand Luke, which is such an old movie. But
Nice.
people might comment we have a failure to communicate.
Yeah.
Yeah.
Feel that way here with all the different views between what we're hearing from the state's attorneys, from the Department of Public Safety, the Department of Children and Families, versus what we're hearing from Marshall Paul. It's, and other advocates such as the Major O'Reilly and others. So, that's the problem. I don't think I'm going to solve it today, but I do think there's things in this bill that would be helpful to advance. So we can advance parts of it. But maybe yeah, I don't want to take away what somebody already has in terms of the with current law. Sort of like the conundrum with raise the age. So,
Senator Sears?
Yep.
I would need a little more time to think about it, but I just put this out there as it does seem as though the list of qualifying crimes that was recommended by Justice Oversight that's in this bill that you just tweaked a little bit has generally been, I haven't heard a lot of opposition from witnesses or conflict, so I would just say that might be, in terms of looking how to move forward on something, I would just put it out there about that. That does seem to be one of the less controversial pieces of it, in terms of trying to address someone like what Senator Benning said, which is someone doesn't have access to the current system. I mean, it doesn't get you to the one track, it doesn't settle the issue of access, but.
Do you mean, go ahead.
You mean allowing certain, adding to the list of what are expungable crimes under current law?
Right.
Right, to me, that kind of seems like the lowest hanging fruit that, there, and I don't know, maybe if then that's what we focus on, then people talk about that they don't like that. Yeah, it's possible, but, and people have just been focused on the other things.
That was one of my suggestions, and I think it's a good one, is that we could add to the list of crimes that are expungible and pass that. Without getting into sealing and the dual track.
I would support that, and I think that would be useful, but I would imagine that some of the stakeholders at this point would then say that they can't go along with expanding expungement because it moves away from the one track idea. So I don't see that we are going to wind up with everybody's support on this bill.
I agree.
So I think we're going to have to pick a direction and maybe go into a conference with the House and, with the understanding that it's just not a popular concept generally with DPS and DCF that they be restricted in their information.
Right. So again, people are pretty familiar with the crimes. So if you could prepare that for next week, Michelle, what crimes would be added to the list of expungible crimes that are in this bill that have already passed the House? Not adding anything new in. And also do we still need the section on the undisclosed access? I think it helps for even juvenile records.
Yeah, I think that we should have that. Undisclosed access and disclosure.
But yeah, that's one alternative. And you're right, Senator. At least it gets us to a position, it would not be all for naught.
And then maybe next
We
year.
basically seal traffic offenses. Am I correct? Currently, we seal things like DUI 1, right?
Under current law, that is eligible under certain circumstances. The proposal in 534 doesn't differ on the DUI, but you did, if you're talking about traffic, like just general motor vehicle violations, that you passed an S7 last year, so that there is a process where those are sealed after 2 years.
Right. So. All right. Well, why don't you work on a draft like that? Is that something the committee would be wants to look at?
Yeah, sure.
There are other things that should be in there.
Snatching. always eligible?
Body snatching?
Yeah, body snatching, is that always eligible? It's in here.
Fuck. I'm
What is
sorry, I'm not.
body?
Is that where you dig up?
Body snatching.
Dig up a dead body?
It used to be very common for training medical students
Oh,
in
right.
the old days, but it's not so common now, but if it happens, I don't like it.
Well, one of the, back in the day when, I remember Hull Maynard making a speech on the floor about it, as government operations had come up with a bill in terms of death and the town's responsibility. And he was telling about Hull had been a funeral director, you know, and he was telling about back in the day, they used to drag bodies to the other town line so that that town would be responsible and not the other place.
Boy.
Pertinent to your body snatching.
Yeah. Kind of a little bit like when we did away with the property tax, the personal inventory tax, because everybody said, well, it doesn't do any good to have it because on March 31st, all this guy's cows are here, and on April 1st, they're all in the neighboring town.
Anyway, can we kind of go over that theory a little bit while we've got a few minutes, Michelle?
Sure.
She's working away.
Nope, that's okay. Go over the theory.
The idea about expanding the list of eligible crimes for expungement.
Right. Right, I mean, I think I just need to go through and, you have your list pretty well settled. And I would just need to go through 7602 as it exists currently, which has both expungement and sealing, and look at how that might need to be tweaked in terms of using these new qualifying offenses. And I'm just not sure. I need to kind of refresh my memory about what's on current law and the timing of everything and what goes under certain timing and that sort of thing. And then there may be some policy decisions for you in there. And so I might just kind of try to create the structure and then highlight that for you. And then I can keep the section with regard to the unauthorized access or disclosure.
One thing we should make clear is that okay, 7604, 7605, those are not really changed in this bill, correct? He's not, because I remember that coming up.
We changed those from expungement to sealing because you were eliminating expungement as.
No, I understand that. There was some, when we passed S7 out of the Senate, there were allegations that people who were charged with a crime, but this covers that, right? We're getting one thing expunged, but not but they had committed a new crime. I think this covers it. Never mind. I don't need to ask that. All right. We're just looking it over to see what's. Well, you'd keep the expungement of municipal violation records.
Oh, right. Yeah, I mean,
Seven?
that's another section, right? That's, I don't think we've heard anybody oppose that. That was something that was requested by the city attorney from Burlington, and you haven't changed any of the language here from what came over from the House. So what that is just modeling it after what you did with minor traffic offenses last year. Except they have for the municipal, it's a 3-year sealing, and as opposed to a 3-year expungement as opposed to a 2-year for traffic offenses.
So we do our version of section 6, which is unauthorized disclosure. The House's version of section 7, correct?
No, your version of unauthorized disclosure is section 7, or is that what you just said? I thought you said 6.
He said 6.
Okay.
I'm looking at the House passed bill right now.
I don't have that right in front of me.
Okay, well, R7 and okay, the two issues would be unauthorized disclosure would be in the bill, and expungement of municipal violation records would be in the bill.
Correct.
Are there other things that should be in it that are here?
We'll keep the expungement of no crimes are no longer crimes.
Yeah.
Yeah. I would think so.
Yeah.
I would hope so. I'm just making sure we're covering all the bases.
That's what, yeah.
Move forward with opening the retail market at the same time you've got people with convictions.
I know.
So I'll leave you the best of this one.
Is there anything else?
We should award Michelle a medal.
We're not done yet. I feel like now I've,
All those hours.
yeah. I'm going on for a while.
Have we put in more hours on this one than on adoption?
No,
I don't think so.
well, yeah,
Oh,
if you
yeah.
include multi-years.
Well, yes.
Yeah.
Well, I mean, we could ask for. No, we don't need to. Tucker, Evan, Jennifer, Lori, any final comments, and Marshall before we hang up?
I have nothing. Thank you for giving us the opportunity to present today.
Okay, you're welcome. Anybody else with any final comments before we adjourn the meeting and get out early?
No,
Evan?
thank you. No, thank you.
Okay.
Lunch.
Oh,
Yeah,
oh, you can.
We're at
it's the biggest building.
the Quonset hut shape
Oh,
on
no.
top of that.
No, it's right on Main Street.
Are we still